Well, I've been asked to talk about international issues of UK corporation tax, and the original invitation, and I need to find out, asked me to look at 4 questions. How has UK corporation tax changed over the years? What have been the main challenges for the taxation of multinationals? What lessons can we learn? It assumes we can learn some lessons. And what are the key challenges over the next 10 to 20 years? And being a practicing barrister, used to following my instructions, well, at least reading them sometimes, I'm going to stick to those questions. So how has the system changed over the years? I was tempted to show a picture of myself in 1965, the picture now, but I was in short trousers in 65, and I don't think anybody could take that on an empty stomach. We've seen about the change of the rate of tax, scope of tax. Of course, in 65, worldwide taxation of UK resident companies, non-resident companies, liable if they traded in the UK through a branch or agency without any detailed rules about how you determine that. So it was simply income from trading through or from a branch or agency, or income from property held through or from the branch or agency. Relief exclusively by credits, with underlying relief if you held a 25% shareholding, and transfer pricing in one section, Section 770. There's going to be quite a bit of nostalgia and sighing from some of us. The days when transfer pricing was limited to sales at an undervalue or at an overvalue. Also, 65, no CFC legislation. How did we survive there? And what we sometimes forget, Treasury consent for transfer of residents overseas. I'm going to make this point several times, but for half of the 50-year period, it was a criminal offence for a UK company to transfer its residents overseas without Treasury consent. It's not until the Daily Mail case tests that and the law is changed. So for only half of that period have we effectively had freedom of movement. And then also in 65, the domestic legislation is only half the story. Double taxation conventions. In 65, we had 71 tax treaties in force, which was a pretty large number. I think then as now, we led the world in concluding tax treaties. But of course, that wasn't very difficult because many of them were colonial arrangements with our former colonies or existing colonies. So the advantages of having a tax treaty with the Solomon Islands or St. Kitts and Nevis or the BVI there. In Europe, at the time, we only had 14 treaties in force. Look at that list. Even in Western Europe, no Spain, no Portugal, no Luxembourg. How did they get interest out of the country? And of course, no Eastern European countries at all. Well, contrasting those points with 2015, of course, we've gone from worldwide scope to not completely territorial, but of course, optional territorial regime. The vast majority of dividends and optionally PE profits taxable on a territorial basis. Non-resident companies still liable if they trade through now through a permanent establishment, but with detailed quasi-AOA rules to quantify that amount. Relief, therefore, now being by credit or by exemption. We still have the growing mass of the credit code there because we're not a completely territorial country. But of course, one of the big changes in the 50 years, comprehensive transfer pricing legislation. Transfer pricing geeks now know not how to price, but also how to determine everything on an arm's length basis. In fact, I saw a bumper sticker recently that said, transfer pricing specialists do it at arm's length. And it occurred to me that if one procreates at arm's length, one soon ends up to the demise of the species. We have, of course, now, we're into our second generation of CFC legislation. We've been through our first bout of CFC, and we're now into our newer, probably EU-compliant CFC legislation. And in place of Treasury consents, we now have the ability to move companies around with deferral of tax on some exits from the UK. And on the tax treaty front, we have now, again, I think it's still the world's largest network of tax treaties, 117. And intriguingly, some of those colonial arrangements, like the 1950s ones with Jersey and Guernsey and the Isle of Man, are still alive 50, 60 years on. So that's how much it has changed over the years. Just running quickly through some of the milestones, I went back and looked at the Finance Acts here, and it's interesting to see how in the early years, each Finance Act virtually had changes to double taxation relief, adjusting the conditions for and the circumstances of underlying credits. Then we have the imputation system in Finance Act 1973, taking effect from 72, Finance Act taking effect from 73, which required the renegotiation of our treaties, and of course the big renegotiation, the US treaty, where we extended dividend tax credits to non-residents for the first time. Carrying on, I also looked through my files at home for some of the key condocs over that time. And on the left is actually the oldest condoc that I have in my files, which is from January 1981, a consultative document on company residence. And that's what condocs looked like in those days. And then intriguingly, on the right-hand side, shortly thereafter, November 1981, a consultative document on company residence, tax havens, and upstream loans. It's interesting to see, and I'll come back to this later, how company residence was a significant issue in the earlier period of corporation tax, one we may have to come back to. Moving ahead with the consultative documents, I did say there'd be a fair amount of nostalgia here, though, of course, as we all know, nostalgia isn't what it used to be. Some of us will remember the consultative document on the taxation of international business in 1982, which gave us our first bout of CFC legislation. And then a few years later, I picked up particularly the legislation in FA 1986, following on the decision in Collard of Mining and Industrial Holdings, because it shows already by then the tension between a credit system and the imputation system, and how difficult, if not impossible, it was to work the two side by side. Another consultative document there, now on dual resident companies. By now, the changes to corporation tax are coming pretty thick and fast each year. I'm not going to run through everything, but if you look on the right-hand side, you will see provisions on dual resident companies, and in 88, for the first time, a move from central management and control to residence based on corporate incorporation, and the migration provisions coming in. And 2 years later, the semi-abolition, not the complete abolition, but the abolition of much of the Treasury consent regime, which is why I say that for half of the period, companies could not move, and half they have been able to be there. And then various CFC changes, bringing up from 50% to 75% of UK tax. FIDS coming in 94, already mentioned, one of the attempts to answer the problem of DTR and the imputation system. DTR limits in 97, and then the new transfer pricing, broader legislation, Schedule 28AA, in 1998. Those are a couple of the condocs at the time. Now, some of you may well sigh with the memory of this. The two green papers on double taxation relief. The left-hand one, still I think one of the best discussion documents on the options between credit and exemption, with a real discussion of SIN, not S-I-N, but C-I-N, capital import neutrality and capital export neutrality. The review, which then led to the somewhat disappointing and very problematic outcome of the review on the right-hand side, with restrictions on mixers, youths coming in, and the eventual onshore mixing as well. Just to note here also, virtually every year changes to the CFC legislation. And I guess it's something one might learn, that if you've got to the point where you're changing your legislation every year, then that legislation is clearly pretty problematic. And that carries through into the 2000s. You will see CFC changes virtually every year, including some driven by EU developments after Cadbury-Schweppes. The condoc in the middle there, the discussion document, is of course key in the changes, because it's that 2007 paper which is really the start of the move towards a more territorial system. It's the document that proposed the dividend exemption, which came in 2009, with the corresponding changes to the ADP policy for CFCs, and the abolition of the last vestiges of the Treasury consent. And last of the steps that bring us up to the present time are, of course, the corporate tax reform proposals of 2010, and the roadmap that brings us to our current position of dividend exemption, optional PE exemption, new CFC legislation, worldwide debt cap, reduced tax rates, and everything that's the present time. So that's the overview of how much has changed over the 50 years. What then do I think have been the main challenges for the taxation of multinationals in that time? Well, this is a very personal view looking back over the 50 years, and I think there have been probably 5 main challenges. And I'm not certain that we've actually resolved all or any of them. The first one is determining what profits are properly taxable in the UK. We've seen 2 waves of CFC legislation, the broader legislation from the 80s, then having to give way to the much narrower CFC legislation, largely under pressure from EU law. We've seen the massive growth in the significance of transfer pricing over that period of time, and we've seen also more detailed rules in some areas, and I would say, for example, the 2003 rules on the attribution of profits to PE as an example of trying to write detailed rules in place of much more general provisions that previously covered this area. That's one of the challenges, and I'll come back and see what we can learn about that. Second challenge that we faced was that for most of the period, we had a system of double taxation relief by credit, and I think we probably learned over the 50 years one thing, and that is those systems simply do not work with an imputation system, certainly not of the form that we had. We also saw over the time that if you give a credit, large companies will either use the system for avoidance or they will gain the system. But above all, we saw how we had a competitiveness disadvantage when compared with particularly other European countries that operated with an exemption system. And the in a sense, mainly almost complete abandonment of credit, though not complete abandonment, is the outcome of trying to deal with that challenge. I don't want to tread on Malcolm Gammey's topic for after lunch, but one of the big challenges, particularly of the last 20 years, has been how do you create a corporate tax system which is compatible with EU law? Virtually all of the key elements of the corporate international tax system have had to be changed under pressure, not so much from proposals from the European Commission, we've generally known how to deal with those, but with decisions from the European Court. So CFC reform, UK to UK transfer pricing, query whether that was necessary, the whole issue of getting rid of the Treasury consents, mobility of companies, exit charges, the abandonment of the imputation system, and ultimately the abandonment of worldwide taxation. Arguably all of those have been responses to trying to be compatible with EU law. And in the middle of all of that, perhaps the biggest challenge is trying to create a competitive environment to keep companies and activities in the UK, particularly in the last 25 years when it's been possible for companies to move their residents without needing consent. We need to keep companies and jobs here, and that's led us to the corporate roadmap, to the reduction in the tax rates, to reforms of CFC, and also an element of competitiveness, widening our tax treaty network as an element of being competitive with other countries. And in the middle of all of that, we've had to combat tax avoidance on a regular basis. So those are, I think, the 5 main challenges. What lessons can we learn from the past 5 years? Well, I thought at this point I might put up a blank slide. Yeah. Perhaps that's more a response to the question, what lessons have we learnt over the last 50 years? What lessons can we learn from the 50 years? Well, I think there are some that we can learn, and perhaps we have learnt those. First one, I think we probably have learnt that there really is no perfect or valid way of determining what profits belong in the UK. If a product is manufactured in the UK, sold to a subsidiary overseas, sold then to the customer, do we really know how much of the profit arises here and how much of the profit arises in another country? What if the product isn't a straightforward product, but it's got embedded IP within it? Does that change the equation? What if it's a service that's supplied from the UK? We have a way of calculating tax base based upon arm's length transfer pricing, but does that really give us a truly valid way of determining what profits belong in the UK? We've probably learnt over the period that to be compatible with EU law, a corporate system has to recognize that companies and jobs can move, and therefore there is no question you have to be competitive to survive unless you're willing to go down a route of accepting restrictions that apply to all EU companies. If you don't have those restrictions, then you've got to do something to keep companies here. And that leads me to perhaps the most controversial lesson, and one that people may well actively dispute, and that is, I don't think in the last 20 years or so, one can say that governments have driven corporate tax policy. It's the large companies that have driven the direction of corporate tax policy. So with that in mind, and those lessons, what then are perhaps the key challenges for taxing the profits over the next 10 to 20 years? If we haven't so far developed a rational and valid system for determining what profits can be attributed and taxed in the UK, we will have to try to develop that system. And one of the difficulties there is that we are hampered by the fact that we are tied to arm's length transfer pricing. One of the events of the last 50 years that I didn't highlight was the lead that the UK took for the EU against formulary apportionment in the US. And that's left us with a legacy of being unwilling to consider alternatives to arm's length transfer pricing. And so we're going to have to find some way of abandoning transfer pricing without appearing to do so. And that's going to involve a certain amount of sleight of hand. And there's been a certain discussion about the difference between economists and lawyers. And I suppose lawyers are particularly good at the sleight of hand. We will have to carry on developing a tax system which is compatible with EU law, which is, of course, problematic because we don't always know what that law is, nor, for that matter, does the European Court. I'll leave that side to Malcolm. We have the particular problem now of satisfying the demands of the public and of NGOs, some of whom are given too much attention, but the demands of the public and the NGOs for fairness, and that's rather difficult when, if you agree with me, governments don't control corporate tax policy, companies do. How do you square that particular circle there? We may have to revisit corporate residence as a connecting factor. It's quite interesting to go back to those early conduct and the changes in the 70s and 80s. We are still in part using a concept of corporate residence developed over 100 years ago on the back of the De Beers Consolidated case. Central management and control was developed at a time when the directors of a company, presumably all men, I suspect, sat around a large table at board meetings and decided the policy for the company. That's not the way that companies operate these days, and one day we're going to have to wake up to that element of our definition of corporate residence no longer being appropriate. We will almost certainly, and those of you who are in the Treasury expect demands for more resources from Andrew Dawson and his treaty team, we will almost certainly have to continue broadening and completing our network of tax treaties. If we insert anti-treaty abuse, anti-shopping provisions into all our treaties, it will no longer be possible for investors from countries with which we don't have treaties to shop into the UK. And so there will be pressure for those investors to have a direct treaty with that country. Of course, that gives us problems that some of those countries, Brazil being a very good example, have very different views from us on tax jurisdiction claims. And so we may need to start concluding slightly unusual non-OECD standard treaties, but maybe ones in which we say this is a special provision that we're only going to extend to this particular country because of the tax system there. I've said nothing up till now about international tax disputes, but we have all seen the growth of disputes between countries, and we all recognize that the number of cases entering mutual agreement, entering MAP, is increasing. The resolution of those disputes, however, is not any better now than it was. We're dealing with a system of resolving disputes that is fundamentally over, well, almost 100 years old, developed in the 1930s. And we need to work down that line of improving the resolution of international tax disputes. And of course, through all this time, we've got to accept that we are no longer in control of international tax policy. If we ever were, we will have to respond to international trends. My last comment there, keep our sanity, and our sense of humour. I suspect one of the most difficult jobs in the world at the present moment must be the head of international tax or head of tax in a multinational. Can you imagine coming in on a Monday morning and finding a memo from the chief executive to say, "Good news! Our next big acquisition is in India." You know where you're going to be litigating for the next 20 years. The question then is, do I resign now or do I wait till my stock options have matured? Now, come in a moment to my last slide, and the squeamish amongst you might wish to close your eyes at this point. BEPS. I have spoken so far about international tax without mentioning BEPS at all. But of course, the biggest challenge for the current, recently incoming government is going to be the question of implementing BEPS, always assuming we get agreement on some at least of the outcomes, but that's going to dominate the next 5 years. Judith mentioned David Gauke's speech on the 1st of June. I can't remember, I think David said this in response to a question where somebody asked him about, is there going to be another roadmap for corporate tax policy? And I think I might have dreamt this, which kind of worries me if I'm dreaming about David Gauke. I don't think I dreamt it. I think what David said, and I think he'd be absolutely right, of course, is that, frankly, for the next 5 years, international tax is going to be dominated by responding and implementing developments from the OECD, some from the EU. It's going to be a case of taking our international tax policy rather than creating the policy. So that brings us then to the 50th anniversary. I suppose my last slide ought to have a birthday cake with 50 candles on it. What truly have we learnt over the last 50 years? Well, I think we've got exactly 29 minutes to hear from the audience as to what they think we've learnt over the last 50 years. Thanks very much.